Emerging markets have an abundance of natural resources which provide attractive new market growth opportunities. However, there are also inherent risks for Australian businesses. The growth of these resource nationalism has the potential to jeopardise future investments as well as drive up costs and risks for investors, financiers, operators and service providers. Our speaker tonight is from Ashurst Partners and is a partner of the disputes practice based here in Perth. She has been involved in a wide range of complex contractual disputes, negligent claims and securities enforcement actions, and represents clients in all forms of dispute resolution, including court proceedings, domestic and international arbitration and private mediations. She has acted on matters in the mining, energy, agribusiness, construction, manufacturing, property and financial services sector, particularly those commercial disputes that have been complex and large. So please put your hands together to welcome to the podium Catherine Pedler from Ashurst Partner.
Thank you very much, Ivor, for the introduction, and thank you to Chris for the invitation to come and present to you all this evening. As Ivor mentioned, the presentation this evening is about the return of resource nationalism and what can be done to protect investments, primarily by considering structures up front and engagement that might be undertaken in order to maximise the ability to protect an investment in an emerging market. I just wanted to make a preliminary comment, which is, while this topic is inherently political, the idea of this presentation is not to be a political one, in the sense that it's not a presentation about whether resource nationalism is a good thing or a bad thing, or how it might impact on the local people of the particular state in which the investment is made. It's really more directed at making potential investors into these markets aware of the risks and aware of the legal structures that are available that might be made use of to maximise the value in an investment and reduce the risk associated with it. So just to set the scene of what we are talking about, what is resource nationalism? It's a very broad umbrella to refer to various steps that might be taken by a host state that might impact on the economic value or certainty around an investment. And we should note that there's nothing new about economic or resource nationalism, and nor is it restricted to emerging markets. So, for example, we've got some first world examples up there: the US tariffs to protect its own steel and aluminium industries from last year, Australia's own domestic gas policy, and also some elements of economic nationalism coming through in the current Brexit debate going on in the UK. So it's certainly not limited to emerging markets, but it's something that can be more prevalent given the uncertainty of some of the local law systems in place in those markets. The other preliminary point to make is that it's not always as overt as soldiers at the gate, and in fact these days it's probably much less likely to take the form of some sort of direct nationalism in that sense. So we have a lot of indirect examples, for example, changes to tax regimes in the mining sector. That can particularly be in relation to royalties, changing to licensing regimes and environmental regulation that might impact on the fundamental economics which underlay an investment at the time of its making and fundamentally change the outcome for the particular investment. So while we've got some specific examples of nationalisation of industries up there, it's not always that direct or that obvious. Now, how is resource nationalism or economic nationalism perceived in the international law context? So up there we have a statement from the United Nations General Assembly resolution all the way back in 1962, which essentially adopted all nations' right to have permanent sovereignty over their national wealth and resources, which must be exercised in the interest of their national development and of the well-being of the people. But since that statement and throughout the 1980s, we've seen an increased growth of bilateral investment treaties between nations. And this is essentially a recognition by these developing economies that in order to maximise value in their own natural resources, they in fact need to access foreign investment to put them in a position to do so. They simply don't have the domestic wealth to access the resources in the way that they might otherwise. We'll just talk in a little bit more detail about some recent examples of what we consider to be resource nationalism. So the first one is the Tanzanian regime that was put in place in July 2017. Now, this was a series of policies that came together into various amendments to acts which are set out up there. I won't go through them all in detail, but these pieces of legislation were all aimed in some way at the mining sector, were given a measure of legitimacy by being linked to the UN resolution around permanent sovereignty. And it also reflected Tanzania's history of losing claims before investment treaty arbitration tribunals. So this was a way of changing the domestic law to essentially protect the steps that Tanzania was taking to nationalise various investments. An example more closer to home for us in this region is an Indonesian example where Pertamina, a local company, took over the role as operator of the Rokan oil block, which had been a role undertaken by Chevron for more than 50 years. And according to the ministry of the day, the decision was made purely on business and economic considerations, but query what more was underlying that decision to oust Chevron after all of that time. So now we'll come to talk about the types of steps and considerations that investors might take into account at the stage of investing into the markets. Importantly, once the investment has already been made, you're essentially subject to the regime as it exists at the day and as it might change. So the protections that we will talk about are all things that need to be considered up front. I won't talk too much about the diplomatic engagement, because I'm sure that's something that those who are familiar with investing in emerging markets have front of mind. But it is an important thing to take into account. And when we're talking about engagement, we're talking about engagement at all levels. So it's not just the diplomatic engagement, but it's the extent to which engagement can be tapped into at the community level. You're much less likely to see protests in relation to your potential mine if you have had that grassroots level engagement and demonstrated the potential benefit to the local community by way of jobs, increased infrastructure, etc., that will result from your mining project, for example. So it's not only diplomatic engagement, it's grassroots engagement that's very important. There are steps that can be taken by an individual to protect the own position by way of political risk insurance, for example. But what we're really focusing on in this evening's presentation is what we've described there as the legal bedrock. So investment protection mechanisms, which can be found in these bilateral investment treaties, which I've mentioned and which I'll come on to describe in more detail. Stabilisation commitments that can be drafted into the contract at the time of investing. And also giving consideration to having a neutral governing law in your relevant investment agreements, and any disputes to be referred to international arbitration rather than dealt with by the local courts. And we'll come on to talk about each of those in turn, starting with stabilisation commitments. So what is a stabilisation commitment? Essentially, it's a private law contractual commitment, so it finds its way into your contract by way of a clause. And what it seeks to do is freeze the relevant legislative or regulatory position as at the date of your investment, such that you are not then subject to changes in the relevant law or regulation throughout the course of your investment. Now, the important thing for these to be binding are the parties to the relevant agreement. So these will only be an option available to you if you are in fact contracting directly with a government agency or have a government agency as a party to your contract. And with that, consideration needs to be given to what type of government agency you have as a party. If you have a contractual commitment from a government ministry, for example, ministries, as we all know from our own even local experience, get reshuffled, restructured, folded into other ministries. So if you have a contractual commitment from a ministry, for example, it may not last, the ministry itself may not last the length of your contract. If you are contracting directly with the minister, who is in fact part of the sovereign, that is a much harder party to get rid of. So you're more likely to have your stabilisation commitment lasting throughout your contract, including through changes of government. We've got a couple of examples of stabilisation clauses up on the slide. The first is what we've described as a freezing clause example. And as you'll see, that seeks to prevent the government from exercising any legislative authority to amend or modify the provisions of the particular agreement throughout the course of the contract. The second is a more limited example of a stabilisation clause, which is described as a variation as to scope. In other words, it seeks to limit the application of any relevant changes that are made throughout the contract. And because it's more limited in scope, it's probably much less likely to challenge. So there is quite a large scope for challenge to these stabilisation commitments that can be in a contract. Firstly, it won't come as any surprise to people that they may be challenged on the basis that they are unconstitutional, and that's particularly the case with respect to the first one, which essentially seeks to tie the government's hands, not only the government of the day, but future governments in relation to making any legislative changes. In some cases, it's possible to turn those commitments into what we would understand in the WA context to be state agreements, such that they are in fact obligations of the government that take on the letter of the law, which makes a constitutional challenge less likely. But of course, this will all depend on the local law of the place in which you are making the investment. One issue with respect to stabilisation clauses is what we've described as the political lightning rod, or the reputational issues that might go along with seeking to enforce them when you are in fact some years down the track into your investment. You're seeking to enforce a commitment given by a government perhaps 2 or 3 revolutions ago in an emerging market, and people might think, look, you strong-armed this government into giving you this commitment because you knew they were desperate to get this investment off the ground, and now here you are, big investor, seeking to strong-arm this new government into recognising and upholding this stabilisation commitment. So there can be reputational issues to navigate when it comes to actually enforcing. It is possible for these private law commitments to be given internationalisation or international recognition if they are captured by umbrella clauses in an investment treaty, which we'll come and talk to in a minute. And generally, if they are subject to international arbitration in a neutral seat, then they are perhaps more likely to be upheld than if you are seeking to enforce them in the local, pursuant to the local law in which the investment has been made. In other words, if there is the government of the day seeking to overturn such a clause, they might get more sympathy from their local courts than they would from an international arbitration tribunal. So stabilisation clauses are raised as an example of something worth considering. If they can be negotiated into your contract, you would rather have them than not, but you may well still face issues when you come to the enforcement and reliance stage. That takes us on to what we consider to be a preferable form of protection if it can be accessed, and that is a treaty-based investment structure, which essentially means that the investing party and the investor state have a bilateral investment treaty between the 2 relevant states that can be relied on by the investment party. So we'll take a quick look at what these investment treaties are, what type of protections they provide to investing parties. We'll look at the Australian position, which is quite limited in terms of the number of bilateral investment treaties that Australia has, but also suggest some ways that some other bilateral investment treaties can be accessed by looking at the structure of your transaction up front. So in order to qualify for protection under an investment treaty, the main qualifying hurdle is nationality. And I should note that any of these comments about the bilateral investment treaties are very general in nature. Obviously, you would need to look at the particular bit in play between the 2 relevant countries to determine these questions. But generally speaking, there is quite a low threshold to establish that you have the relevant nationality to access the BIT. So you either have to be, if you're a corporation, registered in the relevant state, or have a majority shareholder registered in the relevant state, or if you're an individual, be resident or a citizen of the relevant state. In a large number of cases, a brass plate entity will suffice, and by that we mean an entity essentially interposed into an investor state in order to make the investment into the BIT state that you're dealing with. So, for example, if an Australian company was looking to make an investment in Senegal, for argument's sake, Australia and Senegal do not have a bilateral investment treaty, so none of these protections would be available if the investment was to be made by the Australian entity and the contract was with a Senegalese entity, or if, for example, the Australian entity decided to incorporate a Senegalese entity to be the vehicle through which the investment was made and the contract performed. However, the important thing to note about Africa is that African states have a large number of bilateral investment treaties with a number of other African states, for example. So one that we see quite commonly used is the Mauritian incorporation, and that's because Mauritius has a vast array of bilateral investment treaties with African countries, including Senegal, for this example. What it does not have is a denial of benefits clause. And what a denial of benefits clause essentially does is say, if you are simply incorporating an entity and funneling your investment through that entity just to gain access to protection under a bilateral investment treaty, that's not good enough. You have to have a proper business and presence in Mauritius in order to access that protection. There is no such clause in the bilateral investment treaty between Mauritius and Senegal. So in the example I've just cited, you could consider, if it suited the other parts of your transaction, and if you considered the tax position, for example, you might decide that you would incorporate a Mauritian entity who would act as an intermediary between Australia and Senegal, so that if there were any issues down the track, you could access the benefits and the protections provided under the BIT between those two entities. There is an important issue around timing, and this is why I keep coming back to structuring the transaction up front. Firstly, it's important to understand, was the treaty in place when the investment was made or when the contract was entered into? So it really freezes time so that you can access benefits that are in place when you are making your investment. It's also important to note that you cannot interpose an entity once an issue has started to emerge. So if you can see that there's some sort of issue that you might wish to avail yourself of a bilateral investment treaty such that you then try and stick your Mauritian entity, that will not be good enough. You must acquire the benefit and the protection of the treaty up front. You can't acquire it just at the time that the dispute arises. In terms of limitation periods, helpfully, there are no relevant limitation periods in the sense that you can access the protection from the time that the investment was made right through to seeing your contract to the end. Another important thing to consider if you are looking at availing yourself of BIT protection is whether there is a fork in the road provision. And this is important because some relevant BITs contain these provisions which say essentially when a dispute or an issue arises, a party needs to decide, is it going to go down the route of accessing protection under the bilateral investment treaty, or is it going to go down the more traditional court route and access the local courts, for example, if your contract is governed by local law. And once you have gone down the court route, you've shut off the BIT route. So it's very important to make that decision up front before any buttons are pressed under either the BIT or the court process. And the final thing to consider at the stage when a dispute is arising is whether the relevant bilateral investment treaty contains an obligation to negotiate before any buttons are pressed on commencing international arbitration, for example. And those obligations to negotiate must be adhered to very carefully. And again, it's important to understand the terms of the particular bilateral investment treaty that you are trying to access. So now I was just going to run through, again in very general terms, and it will always depend on the particular bit in place, but what are the protections that you can access if you do have access to a bilateral investment treaty? So the first and most important protection is against expropriation of your asset. And importantly, and referring back to what we said at the beginning, this is protection against direct expropriation, so for example, seizing an asset, but also indirect expropriation, which can result by way of creeping tax changes or regulation changes, etc. And it can protect measures tantamount to expropriation, which is what brings in this indirect expropriation concept. So this is quite a wide protection. The essential question as to whether or not there may have been a breach is whether the investor has been deprived of the enjoyment of the investment, subject to the reasonable expectation of economic benefit that would arise as a result of the investment. Protection is also granted with respect to the treatment of investors and whether they've been subject to fair and equitable treatment. Now, this is more looking at things like procedural failures, lack of being given a proper opportunity to be heard in relation to things which affect you. Were relevant decisions arrived at through a fair and transparent process? So if we look back at the Indonesian example we spoke about at the beginning, that might be an example where Chevron could access the bit, if there were one in place, and say, I'm not satisfied with the process that was undertaken in removing me as operator of that project, and I'd like to have that assessed. There is protection provided in a bilateral investment treaty for that. Importantly, there's no need to establish bad faith in any process. So again, it doesn't need to be some fundamental corrupt act that resulted in your investment being affected. Pure incompetence could suffice. So you could open up a decision-making process to review simply because it wasn't fair or transparent, or there was some issue with the decision-making process itself. And the final important area of protection is full protection and security. And what we're talking about here is physical protection and security of an investment. So, for example, failure to prevent damage, if there are protesters threatening physical damage to a piece of infrastructure, for example, or a failure to adequately police, that can be protected by way of a bilateral investment treaty. If you can establish that there has been a breach of the bilateral investment treaty, what does that mean for you? Well, importantly, it means compensation can be awarded against the host state, payable directly to the investor. The compensation has to be measured to be fair and equitable. Now, one challenge in establishing a right to compensation is that, generally speaking, the investor is required to demonstrate some sort of record of profitability. Now, this can be difficult if you're in a grassroots investment, which is going from the ground up. You're at the early stage. You haven't yet started production or whatever it is you might be doing with your investment, such that you cannot demonstrate that record of profitability. The other issue is that expected profitability, for example, might be subject to quite a heavy discount for sovereign risk, which sort of seems slightly circular, but it is the way we see these things operating in practice. There is a duty to mitigate any loss, so this can again come to, have you taken your own measures to protect your investment at the relevant stage? For example, the political risk insurance that we've talked about. And importantly, costs, just like a normal dispute, costs will generally follow the event, so you can claim your costs for seeking to enforce your rights under a bilateral investment treaty if you are successful. So again, just pausing there to compare, as we did with stabilisation clauses, what the difference is essentially where you have a bilateral investment treaty in place and where you don't. Generally speaking, you'll be left to bring your case in the courts of the host state, which will be subject to a political overlay that you might not have a lot of influence on. Or you could lobby the home state to intervene and try and get a diplomatic solution. Where you have a treaty, your option, again, considering your fork in the road obligations, is to commence an investment treaty arbitration. And these are getting a little bit more press lately. There's been a few more actions taken in this space. And the benefit of an investment treaty arbitration over pursuing your case in the local courts is that you will have a neutral panel, generally not from either the host state or the investor state. They'll be selected by the parties and also then potentially select their neutral chair, and they'll render a binding decision on both the host state and the investor. Then, assuming you get a positive decision on your investment treaty arbitration, how do you go about enforcing it? So you'll see up there a large portion of that map is covered in either blue or yellow. And that represents states who have either contracted to the ICSID Convention, which is the Washington Convention, where arbitrations under the provisions of the International Centre for the Settlement of Investment Disputes are concerned, and the yellow are signatory states. So any of those blue or yellow states should enforce an investment treaty arbitration decision. Even if your arbitration doesn't go under the ICSID rules, if you access, say, the International Court of Arbitration or an UNCITRAL governed arbitration, again, the New York Convention for Enforcement is quite wide-reaching, so that you should be able to go to the host state against whom the award has been made and enforce that award in the courts of that state. And when you're talking about enforcement of a monetary award, that political overlay becomes not completely irrelevant, but much less significant than when you're asking the courts of a local state to actually adjudicate on the substantive dispute. So if we have a look now at the position in Australia, as I mentioned at the beginning of the presentation, Australia has relatively few bilateral investment treaties. In fact, only 18 at the moment. It has 8 fair trade agreements, which do contain some measure of investment protection, but it does not have a good claims or enforcement history. And that's why it's really important to consider at the time of making your investment whether there are some other bilateral investment treaties that might be accessed by structuring your transaction. The other point just to make about the bilateral investment treaties, it might all sound a bit dramatic to be running off to international arbitration and suing a host state for vast amounts of compensation where an issue arises on your investment. But this raises the question of having access to these tools that you can use, which are essentially things that you can use as leverage at the stage where a dispute might be arising. Now, conscious of the time, I won't go into all the details of this particular example, which is one that my colleagues in London worked on. But it is an example of how a bilateral investment treaty was used as a key negotiating tool to obtain essentially what was required without having to pull the trigger and start an international arbitration. So in this particular case, we were acting for a client who had a mine in Kyrgyzstan. The mine was up a 30-kilometre road, very thin road. People lived up at the mine in a sort of drive-in, drive-out type scenario, so they had all their food and everything up there. The local residents were not happy about this mine and blocked the road so that nobody could get up or down, and kidnapped the local governor and said, we're not releasing him until this mine is closed and we're not unblocking the road until that occurs. So this was a case where our client was seeking the assistance of the local police to clear the protesters away, to unblock the road to the mine so that operations could continue, food could be taken up there, the product could be taken down, etc. Now, the local police were having none of it and were simply saying, it's nothing to do with us, we're not going to help you. So rather than saying, well, right, we're off to international arbitration, you know, you'll get your referral to arbitration in the mail tomorrow, engagement was had at the diplomatic level with the Interior Ministry. And the people who they met with at the Interior Ministry had no idea about the bilateral investment treaty or the obligations under it, or the rights that our client could exercise by starting international arbitration. And it was made very clear that if proper engagement wasn't had, if the local police weren't instructed to go and remove the protesters, that this step would have to be taken. And in that case, that was enough to get the right people talking to the right people to get the police moved and the mine up and running. So it's just an example of being aware of what protections are available, engaging at the appropriate level, and using those as leverage rather than having to actually run off and go the nuclear option and commence your international arbitration. So just really summarising now the proactive steps that investors can take. Where there is a good faith attempt to gain treaty protection, even via use of a brass plate entity, that is a perfectly legitimate goal, as long as it's done at the right time and with the right intention. If someone is motivated wholly or partly by a desire to gain access to investment treaty protection, and for a specific dispute that exists or is foreseeable, you are unlikely to be able to access treaty protection in that case. So that's why, again, the upfront structuring is crucial. And the final word on international arbitration, and this is something that can be used either in the bilateral investment treaty context, where you have a dispute and you think you can access some bit protection, or again, in just structuring your transaction up front and looking at your governing law and jurisdiction clause. Generally speaking, we will see counterparties in these emerging markets seek to have the local law govern the terms of the contract. We generally recommend that parties choose a neutral governing law, such as English law or Singaporean law, for example, and submit any disputes to international arbitration. So again, they can be dealt with by a neutral panel rather than the courts of the local jurisdiction. Now, there are some limitations on those constructs. So, for example, there might be mandatory local law applicable to pre-arbitration proceedings which occur in that jurisdiction. There are some disputes which are not arbitral. For example, tax disputes generally can't be subject to arbitration. So it won't necessarily cover the field, but we would always suggest that as a more neutral structure, more likely to give you certainty of result than if you submit yourself to the courts of the local jurisdiction. So in closing, hopefully that has given some overview of some of the legal constructs that people can use to try and protect their assets. We don't suggest that they provide all the answers, or that you necessarily do want to invoke the nuclear option all the time, but certainly it's something worth thinking about at the stage of investment, so you put yourself in the best position if you do find some of these resource nationalism impacts impacting you through the course of the investment. That was all I had. Thank you.